This is Headnotes, a podcast from Whitehead Monckton.
Hello everybody. Thank you for joining us for a fairly in-depth discussion about finances on divorce. My name's Graeme Jones. I'm a director at Whitehead Monckton. Been practicing family law for longer than I care to remember and have seen many changes. And I'm joined today by two of my colleagues who I will let them introduce themselves.
Hello, hi, I'm Rhia Davis. I'm a senior associate here at Whitehead Monckton. I've been here now for a year and I've been practicing family law for 13 years, unlucky for some.
I've been doing it 34.
Oh, wow. No comment.
Hi, my name's Stuart Snow. I'm a barrister at Pump Court Chambers and I specialise in financial remedies proceedings on divorce and a little bit of trust of land matters as well. But of course, thank you very much for having me today and inviting me to join you for this podcast.
So we thought we needed somebody with proper knowledge. So where do we start? I suppose we're looking at finances and how you sort out your finances on divorce and sort of areas outside of court. So should we start by outlining what people would have to do if they've got a financial dispute on separation?
Yes, of course. I wonder if it's worth us starting with the fact that we're going to probably have three potential stages within the financial remedy process, which of course we start with our computation stage of the process. We have a disclosure process that we undertake in terms of understanding exactly what is in the pot for everybody to have available to distribute at the end of the day. So we tend to start with that process at what the court would say is a first appointment. And of course, we prepare Forms E, which are disclosure documents. I think probably
a very long disclosure document. I think if you just think of it as setting out everything you've got in a booklet with lots of documentation in support, that explains what that'll be.
Yes, quite. And once we've done that first stage of the process and the court has got an idea of what is in the pot available for distribution, we move on to stage 2, which we call the financial dispute resolution appointment, at which we have a judge-led mediation, where the judge gives us an indication as to the likely outcome of your case if you were to go to the third and final step in the process, which is a fully contested trial. And I don't know about your experience around the table, but in my experience, it's about 80% of the time that cases will settle at that second stage of the process at that financial dispute resolution appointment, because the entire system is geared towards us trying to resolve disputes with limited stress, limited costs, and as quickly as possible if we can do. Which, of course, is why we're here today, to try and talk a little bit about the options to make that process even smoother for everybody.
Yes, and I think that's important. I think what we want to do today is drill down into this FDR process and try and demystify it a bit, because nobody ever wants to go to court. And when you talk about this process, clients become very nervous. Obviously, they're relying on us to guide them through the process. But they need to work hard at it themselves, because potentially it's a long process. You've mentioned the 3 stages, but if you end up at a contested hearing before a judge, you're looking at least 12 months to get there, sometimes longer because of the delays in the court system. And the other side of things is it can be an extremely expensive process for the clients as well.
Well, and also in recent years, there's not just a wish to get things resolved on a more amicable basis. You're expected to try. And I was going to sort of explore that a little bit, in that I think it was last April, perhaps 2024, where the FM5, so the form where parties have to declare to the court what steps they've taken outside of the court process in order to try to come to a resolution. What your experience of that form is, Stuart, as somebody that's in court very regularly, how is it being used? Are there any consequences that people are suffering for not having explored what we call non-court dispute resolution, NCDR?
I have to say that in the limited time that judges have at a first appointment, in my experience, it doesn't often get brought up, which is regrettable, because, of course, we are aware that we have got we have got some High Court authority where judges have indicated that a failure to properly explore non-court-based dispute resolution can result in the court pressing pause on its process to allow parties to take a step outside of court again to be able to try and go through non-court-based dispute resolution. But I think that what tends to happen when you do get on the ground to a first appointment at the moment is that things are so rushed. Unfortunately, judges have got a lot of cases that they need to deal with, and time is always tight, and inevitably that time has to be taken up with dealing with the directions that we need to explore, and normally quite a lot of argument in relation to further requests for disclosure, i.e. these questionnaires that often get brought up on what other people have already put forward.
Yeah, I think that's worth explaining that with this first appointment, I always say to clients, it's the court's method of getting everything in order, all the ducks in a row, so you can get on to explore. And so things such as, are there disputes as to valuations? What are the pensions worth? Has there been full disclosure of all bank accounts? That's what the court are trying to get to grips with there. But the problem, as you've said, is on the first directions appointment day at court, they will have, 8-10 cases listed. You will get, in theory, you're meant to get up to an hour, aren't you? But you very rarely get that. Sometimes the case will be pulled at the last minute. I think one of the biggest problems is, with the best will in the world, the judge won't really have got to grips with the case because they won't have had very long to read through the papers.
Indeed. As you say, Graeme, though, it's a question of we compute before we distribute, don't we? Yeah. And that's what that process at the first appointment is designed for us to try and achieve. Yesterday, my first appointment only had a 30-minute listing. The court that I was at yesterday was only dedicating a very short amount of time available to the parties there.
Which is a really limited amount of time, particularly, as you say, if there's a raft of cases on that day that the judge has got to try and get to grips with, and then in 30 minutes drill down into some quite meaty issues at times.
I think the pension, because I still think a lot of clients don't realise how important the pension can be as part of the asset base. In a lot of cases, it can sometimes be the biggest asset that's been looking to distribute. And of course, it's not just a case of saying, here's a pension worth $500,000. You have 250,000 each. And what's your experience, Stuart, about judges' views with regard to pensions on divorce experts? I was going to say PODE, but I'm not slipping into jargon. A PODE is an expert who will review a pension and make recommendations to how it should be divided. I've seen recently some pretty big London firms saying, we don't need a PODE report. And you think, really?
I think in my experience, a lot of judges in Kent will expect us to make a Part 25 application, which is, of course, a specific application for the instruction of expert evidence, to be able to rely upon a pensions on divorce expert. But I was trying to rack my brains to think of a time when a judge has actually refused such an application. Obviously, there are cases where the pensions involved are quite modest, and perhaps it's not proportionate to go to the expense of instructing that pension expert. But as soon as you get above a threshold of perhaps £150,000, most judges are inclined to say, yes, you can have that pension on divorce expert instructed for your case. That, I suppose, though, it does come with its challenges in the sense that it takes a long time to be able to process pensions, and it can result in there being a little bit of a delay to the process as you're waiting for that report to be provided.
Yes, I suppose, because I think a lot of clients think, well, if a pension's worth 500,000, do we just want 250,000 each? But it's not as simple as that, and that often takes some explaining to them, that you don't necessarily split a pension equally on its capital value. You're looking at what return you will get on that pension in retirement, and that can vary depending on the nature of the funds, can't it?
Yes, completely.
Or indeed how you might offset it against other assets if that's your priority.
Yes,
in the here and now.
By taking more of the assets that are available rather than a pension that's going to be available in the future. But yeah, it does come at a cost, doesn't it? I mean, it's anything between £3,000 and £5,000 for a pension report, which the parties will share equally.
But as you say, Graeme, it's something which is often overlooked by a lot of clients in terms of the importance of that financial provision. And we can often see parties in cases where they're perhaps more modest assets thinking that priority one is in relation to being able to sort out capital needs, i.e. where am I going to live, and be willing to make a sacrifice in relation to their future financial provision, which is perhaps not necessarily in their longer term financial interests.
Yeah, I think that's again where we come in to try and get them to see the longer term vision as to where they're going to be. And you can understand why they are so present focused. Certainly. Because their relationship's broken down, they don't know where necessarily money's coming from, especially if one spouse isn't working, and it can be very challenging for them.
Very emotional. There's a lot of, I often say to clients, in fact in my first meeting, at some stage you're going to just need to make a commercial decision and so far as possible strip the emotion out of this, but it's such a difficult thing to do. Such a difficult thing to do.
It's easy for us to talk to people about it because it's our day-to-day job and we understand what's going on. But for most people, they won't have been through this before and hopefully will never go through it again. And it can be very emotional and very challenging because you're looking at planning for your future. You're looking at how you're going to fund the cost of these proceedings. I mean, the costs can be horrendous. But I suppose I'd be interested to hear your views on this. Often clients don't focus on the correct issues and they lose sight of what costs they're incurring by virtue of their behaviour. And I think a lot is about managing expectations, which can be very challenging with clients that are going through a lot of emotional turmoil.
Well, and particularly as one of the things which judges in particular hate to deal with is chattels, other things that the emotion is mostly sort of tied to. So I've seen cases where vast amounts of money have been spent. I mean, one springs to mind, significantly more than their underlying value. A lot of money spent on a pair of curtains, and that, if only I were joking.
Well, this process didn't. I think the FDR or the financial dispute resolution process. This all came in around 2000, didn't it? I think initially. I know it was a pilot in 1996, but I remember. I think it was one of my first FDRs, financial dispute resolution appointment. It took place in Maidstone. And we were arguing about chattels. We were arguing about some old cans of oil in the garage and rockery stones.
Oh, I think you've beaten my curtains there, Graeme.
and the judge actually said to us, because it had got to 4:00, he said, I don't care how long we stay here, but there is no way I'm letting you take this to a final hearing. And I think that's the sort of hands-on input you want from judges. I'm not sure if they'd be quite that direct now, but it showed where the whole idea of getting parties to take responsibility for settling has sort of developed and come from. I mean, Stuart, what's your view on how FDRs have developed, or financial dispute resolution hearings have developed over the years?
I think they have become now such a useful tool in the process. As we mentioned at the outset here, in my experience, about 80% of cases now will settle at the financial dispute resolution appointment. And what I always stress to clients is that process, yes, a judge is not able to force an outcome on you, can't impose the outcome, but you're getting the opportunity to control the outcome yourself. So you don't settle on terms that you can't live with. And I think importantly, sometimes it's a question of saying to clients, I never use the word you're going to be happy with the outcome, because it's a question of thinking actually, pragmatically, commercially, like you say, Rhia, what is it that we can get you as the best outcome possible, having regard to the costs involved and the fact that there are risks in litigation. And of course, the difficulty with financial remedy proceedings a lot of the time is that you can put your case in front of 10 different judges and you can get 10 slightly different outcomes to it as well. So that financial dispute resolution process, of course, it allows parties to be able to manage that risk with the assistance of their legal representatives and come to an outcome which they can live with.
I always call it, I say to the clients, you're looking for an acceptable compromise.
Indeed.
I think, wasn't there a judge locally who used to say, if you both leave my courtroom feeling like you've lost, I've probably done the right thing. And I can sort of see the logic of that.
Yes.
Obviously, we do try, of course, to make sure that it doesn't happen. That people
not quite so bleak.
Not quite so bleak at the end of it. But by controlling the outcome, of course, you settle it. You walk away from that hearing at the point where hopefully costs haven't escalated too significantly. So by reaching an agreement, you have stopped the costs from being incurred. And I think importantly, which is something which sometimes is overlooked, is that you stop the stress and the mental health impacts that go alongside continuing and perpetuating litigation as well.
I always talk to clients about that. I talk about the intangible issues that are related to finances, and I think you're exactly right on there. The emotional effect. How many times do we see parties saying in their Form E to the court that this is the health effect this is having on my health? And the flip side of that is, well, yes, that's understandable. In that case, let's try and settle this, because that will then stop.
And I also think one of the advantages of the FDR process is, even where you don't reach that settlement, you're looking into the whites of a person's eyes, and it helps to narrow the issues so much that often, in my experience, if you don't settle there on that day, within the following weeks, you're dealing with one or two issues which you can get it over the line.
You know where the tram lines
exactly.
are in terms of where the parties' boundaries are.
I think it helps focus people's minds, doesn't it? And there, I agree with you. If you don't actually settle on the day at that hearing, that'll lead to further negotiations over the next few weeks, which will often lead to an agreement.
I mean, I often say to clients that the judge will metaphorically bash your heads together and send you out to get it done. And I think that's kind of right, in that it makes them think, and they're being told by somebody that they're not paying for, or is not their opponent, if you like, an independent person saying, actually, this is where we need to be, and this is what you need to be thinking about and concentrating on, and it really helps.
When financial dispute resolutions started, they were very good and developed very well, but I think something we can't skirt around is the inherent problems in the court system that exist at the moment with regard to delay. Putting into context, if you issue a financial application in the court and go all the way, I think I said earlier, you could be more than a year before you get to a final hearing. So it has developed, our practice has developed, of non-court-based resolutions, and something we now call them PFDRs, so private FDRs, and they've been growing in popularity. And Stuart, what's your experience of those?
That they are incredibly popular now, and they are such a useful tool available to parties. As you say, Graeme, with the court system, unfortunately, so backed up, being able to take a case out of the court process and going to an evaluator who is a specialist in financial remedy disputes and asking for their independent and objective view of your case in the same way that a judge would give it to you is such an efficient way of doing things. It speeds things up no end. And of course, you're getting, because you're paying a little bit for it in terms of paying for your evaluator, you're getting their dedicated time for an entire day. Whereas, as we know, during the court process, if you're at court, then you tend to have a judge listed with maybe 2 or possibly even 3 financial dispute resolution appointments over the course of a morning session. Whereas if you're taking it out of the court process and going to the private FDR, then you have your judge for the entire day, and they are able to really get down into the nitty-gritty in relation to the issues and explore the assets in a lot more detail than your judge.
And also I think they'll have had the papers in advance, so they'll have read before. Absolutely. So even before that day, they're up to speed before anybody's set foot in the building.
The private FDRs, in my experience, are the way to go. Yes, I think there is the issue of the cost in that in the court process, so if you're using the court-based system, you pay your issue fee at the beginning of the case and you don't pay anything else to the court. Whereas if you're going down the private FDR route, both sides will pay for the evaluator that's going to deal with the hearing. And I think you pay your money and take your choice, 3 to 13,000 easily plus VAT. So you choose. But I think the important thing about the evaluators is they want to do a good job because they want to get more work. So, of course, when you instruct somebody, they are going to be very, very good. And I completely agree with you. With the court-based system, the judge might have 5, 6, 7 FDRs in one day, And with the best will in the world, whilst they will have looked at the papers, they won't have drilled down into them. Whereas when you're using the private system, the evaluator will have had the papers a good week before and will be completely on top. And in my experience, one of the first things that you'll be told is, well, I have my evaluation, but I'd like to hear what you both have to say about it. And so you then have a whole day knowing the person has read the papers and knowing you're going to get good input.
And of course, by knowing that you have chosen who is going to give you your evaluation, because you've taken the time to consider, research that evaluator, you also can have confidence in what they are producing for you. I think it's important, Graeme, if I may just come back on that cost point that you raised there as well, because of course sometimes parties can be, and clients can be a little put off by the fact that there's an extra cost associated with instructing a private evaluator. What I tend to explain, though, is that in reality, because you are able to schedule a private FDR at your convenience alongside your legal representatives and the representatives for the other side, that tends to mean that you can speed the whole process up quite substantially.
Yes.
And as a result of that, you have a little bit of an upfront cost associated with your evaluator, but you're saving costs in the long run no end. And actually, it probably ends up being a lot more cost effective to have gone down that private FDR route than having to wait for a court-based hearing, and inevitably there being significant back and forth in relation to solicitor correspondence, further rounds of disclosure having to be undertaken, updating various documents in preparation for a court hearing, which those costs will be saved by virtue of the private process that you can go through there.
I think it's a case of getting the clients to understand that, and it's the quality of the service you're getting within that, because the possibility of settling at an FDR in a court-based scenario where you will have at most an hour of the judge's time, although you are allowed to negotiate for as long as you want, it's not a particularly conducive atmosphere in a court if you've been able to get an interview room, or if there's anywhere where you can talk privately, whereas you have the luxury of time with the private system. And yes, I agree, there'll be a lot of cost and time saved. The other thing we haven't touched on, of course, is the court's habit of pulling hearings at the last minute, which has been happening more and more.
Which has an associated cost, because there are significant costs in approaching a hearing. There's deemed fees for barristers that you may not be able to recoup. So there's significant control issues that you have with the private FDR that you are beholden to the court otherwise.
I think the court can pull a hearing 24 hours beforehand.
Sometimes I think it's 3 p.m. the day before that they can.
And you will just get a call. And I think that's difficult for us because we have to explain that to our clients. And as you say, if somebody like yourself, Stuart's been booked and you're told the day before it's not going ahead, of course you're still entitled to your fee, which is not unreasonable because you won't be able to do any work that day. And the clients say to us, well, why have we got to pay for that? It's the court system. It's the backup problem with the court system, and that's why private FDRs should really be the way forward.
Indeed. And it does, for me in my practice, they represent a significant proportion. I don't think I could probably sit here and tell you an exact percentage. Perhaps I should know that, and I'll ask my clerks to look into that for me. But it's normally, it's a significant proportion of what I'm doing is now private FDR as opposed to court-based FDR.
And has that been a gradual move, or has there been a sort of sudden groundswell of private FDRs coming to the fore?
It's interesting depending on which area of the country you're in, actually, Graeme, because there are different areas of the country where it's not quite taken off as much. But certainly Kent is very pro private FDRs, I'm finding now, and that seems to take off quite quickly. Once I think word got around post-pandemic that it was a good way of being able to resolve disputes more efficiently.
So, should we talk a bit, because people want to know how it actually works. So, a typical private FDR day, what's the process? What's going to happen? What can clients expect?
Yes, indeed. I think we tend to try and meet quite early in the day because the whole point, as we were discussing a moment ago, is for there to be a judge-led mediation. So we start quite early in the morning. We will have an introductory conference discussion just between the barrister and their client together with their solicitor before we then go and see this private evaluator that we've instructed. That evaluator will have already had the opportunity to consider a substantial bundle of documents which have been prepared by the solicitors, as well as a position statement from the respective barristers that have been instructed as well. They will probably then hear some submissions from the barristers to elaborate on what has been written down, before then giving an indication as to what the likely outcome of the dispute would be if it went to a fully contested trial. That is when the hard work starts, because once you've got the indication, you of course know whether the parties' respective positions that they were advancing at the start of the day are reasonable, and you now have an idea as to where the tram lines are going to be and where the issues are going to be for the purposes of negotiation. But that indication is often received normally around the lunchtime in a private FDR, so sometimes 12, 1 o'clock, sometimes 2 o'clock. But then for the rest of the day is when the negotiation happens. And that's when the hard work for the clients really kicks in, because they have to then focus in on what they've been told by the evaluator. And with the assistance of their legal representatives, start going back and forth in respect of proposals.
I think it's worth mentioning, of course, that prior to the hearing or the meeting, both parties are expected to have made offers to the other side.
Yes, indeed.
So the evaluator will have seen both offers and will see where the gap is. And as part of their recommendations, they will indicate how much in favour they are of the respective offers and where they see the problems. And that can often be an injection of reality to the clients, can't it? Because it's the independent person saying what they think might happen.
Indeed, and they will of course give an indication on both any disputes in relation to the computation stage of the process. They can hopefully help with if there is a dispute in relation to the value of an asset or how the tax consequences should be considered on the disposal of an asset. And they will also give an indication on the distribution side of the process too, as to, well, what is ultimately going to be the fair outcome in this scenario, whether it's a case which is going to be dealt with on a sharing basis because there are sufficient assets, or whether we're going to have to go down the needs route where one party might be able to recover slightly more than 50% of the overall assets in order to be able to move on with their life in a financially independent way.
I mean, that's always the difficult thing for the clients to understand, isn't it? Is how the assets or the fruits of the marriage are going to be divided up. And you maybe explain a bit more about the sharing principle, how that works in practice, and how you get deviation from that.
Yes, when we're looking at somebody's entitlement after the breakdown of a relationship and a marriage, we of course look at it from two perspectives. We look at it from a sharing perspective and a needs perspective. Those are the two main driving principles behind it. The sharing principle is where the fruits of the parties' joint marital endeavour are normally shared on an equal basis. Assets which have accrued from a source outside of the marriage, the obvious example being somebody receiving an inheritance, tend to be considered to be non-matrimonial property, so not subject to that sharing principle. Things do get a little bit more complicated depending on how the parties have treated an asset over time and whether they've treated it over time as shared between them. In that scenario, an asset which has started off as being non-matrimonial can morph into, become matrimonialized. Don't look that up in the dictionary.
Great word.
They can become matrimonialized and form part of those matrimonial assets and can form part of the sharing principle. We can then, of course, potentially have arguments in relation to whether or not something which has become matrimonialized should be shared equally or whether it should be shared unequally. But it just goes to show that, yes, it's very easy to say, well, yes, sharing principle means 50-50, but in reality there can be arguments that go surrounding that.
And I think this goes back to the point we made earlier about the evaluator having that in-depth knowledge, because these are really tricky issues to try to, in an half an hour listing for a judge at a court-led FDR, to really get to grips with what's being said by whom and what's correct. But somebody that's had those papers for, as you say, could be up to a week, they've read them, they've then heard further submissions from you, is going to have so much more of a handle on that side of things.
And I think it's important, how the message is delivered as well, because it might be an inherited asset. It might have been kept away from the marital pot, but there's a terrible phrase, but need trumps all. If there is a need for the court to have access to it, they will, and you need to explain that.
And again,
that
goes back
clients.
to the emotion, because
Yes.
inheritance particularly has a real emotional tie to a client. So to be able to then say, I'm afraid it's up for grabs, can be really difficult.
But of course, it will only be invaded to the extent to which needs need to be
Absolutely.
met.
Yes.
Unless it's been matrimonialised.
Unless it's been matrimonialised.
Wonderful word again.
Don't look at the dictionary again.
It might be worth explaining a bit how, because the private FDR hearing is not part of the court process directly. So how if clients are going to want to go down that route, how does that fit in? How do you organise it? How do you loop out of the court system and then get back into it? And what happens if you reach your agreement at the private FDR? What happens then? How do you get a court order?
Well, I have to say, in a lot of cases now, parties don't even go anywhere near court to begin with.
They call it early neutral evaluation.
Early neutral evaluation.
Yes.
And we find that because solicitors have already established that this is a case where parties are willing to consider the out-of-court processes, what they have done is that they've exchanged their disclosure documents voluntarily between the parties, realised that unfortunately it's not going to be possible to reach an agreement without some further assistance, some objective help, and they've set up a private FDR voluntarily between the parties. And there are on some occasions where I've even seen it go that one step further to say, well, even before issuing proceedings, the parties have then agreed to go to the third and final stage and have an arbitration.
Yes.
Even before anyone has pushed any sort of button in terms of going towards court.
I think it's probably worth explaining what an arbitration is in case listeners aren't sure what we're talking about on that point. The arbitration being effectively a private court hearing where you appoint, rather than an evaluator, an arbitrator who will make a decision having heard all the evidence.
A binding decision.
A binding decision, yes.
Which, of course, is different to the private financial dispute resolution appointment where you're getting a evaluator to be able to assist you and give you an indication as to the likely outcome. When it comes to the arbitration stage of the process, you are a private trial. And because it's a private trial, the arbitrator will hear cross-examination, which doesn't happen in the private FDR process. They will hear closing argument, they will see a lot more evidence, and it will be a slightly longer process before the arbitrator as compared to before your private financial dispute resolution appointment evaluator there. But you're right to say, Rhia, that once an arbitrator makes a decision, it's binding upon the parties. It's an outcome which has been imposed on the parties in the same way that a trial judge would do at the conclusion of a final hearing if it was in the court process.
So you're looking, whether it's a private FDR where you agree it or an arbitration, you haven't got your court order. What happens if one party then decides they don't like what's happened?
Well, with an arbitration, they've signed up to an agreement at the start of that process to be bound by the decision. So my understanding is that the other party would make significant applications to the court to have them held to it. Certainly.
Indeed, and that's so. If we have if we reach an agreement at the conclusion of a private FDR, then what the parties will do is they will submit documents to the court. They will set out their finances in a summary format alongside an agreed consent order, and they will submit it to the court and say to a judge, we had a private financial dispute resolution appointment. Here are the terms of our agreement. We would like you to now seal that as a court order as being fair between the parties. If the parties if one of the parties attempts to resile from that agreement, well then, yes, if both parties were legally representative, it tends to be pretty difficult to get out of an agreement that's been reached, and either party is able to effectively apply to the court and say, why, prove to me why you're trying to resile. Why is it unfair for us to be bound by that agreement that we reached at that private financial dispute resolution appointment? And the burden shifts entirely on them to demonstrate to a judge as to why they shouldn't be bound by it. The same is true if you go through to the arbitration process, and if you have an outcome which is binding upon you, you should then be submitting that to the judge to be able to say, parties undertook an arbitration, here is a summary of their financial position, here is the arbitrator's judgment, their award in relation to their finances, their decision, and here is an order, consent order, which represents that decision. Yeah. Please approve that for us so that these parties can move on with their lives and start getting on with actually the key important thing is using the money that they are going to receive to be able to move on, buy themselves houses, hopefully, and get on with sorting out their income.
Bearing in mind the private FDR evaluator's indication isn't binding on the parties and that they are then expected to go to the court to ask them to seal that order, to make that agreement binding. Have you ever seen a scenario where the judge at court has questioned it in any way or queried it? Or in your experience, is it good enough for them that a very experienced person outside of the court process has evaluated it, made a decision, and that they're happy? Because, we should make clear that whenever an agreement is reached in financial remedy proceedings, it's not a rubber stamping exercise of the court. They do have oversight in terms of making sure that they consider it's fair and reasonable and meets everybody's needs so far as is possible. Is your experience that essentially it takes that risk away in that? I
think it takes some of the risk away.
Yeah.
I always find that it's quite a limited risk in any event when there are legally represented parties for an agreement to be rejected. It does happen, of course it does. It does happen every now and again. But I was trying to, as you were asking the question, I was trying to think have I had one after a private FDR which has been rejected? I don't think I have.
So it builds a level of, not certainty, but certainly
a level of confidence
exactly.
into the system.
Yeah.
I think the important thing is, because you talked about the document you file with the court with your order, which gives the court the background. There is a box in there that says, is there anything else the court should be aware of? So if there is something unusual in the agreement, that should be explained in the documents that are going to the court to give the court the background.
I was going to come on to say that, so of course, we have said here today that there are 80% of the time, in my experience, where the FDR process, whether it's court or private, is successful. There are 20% of cases, that means, where unfortunately an agreement isn't reached at that private FDR or court-based FDR. And of course, we then have to move on to consider, well, how are we going to determine the party's finances in that scenario? And it's fair to say that, yes, unfortunately, there are some cases where it simply isn't possible for the parties to bridge the gap between them through negotiation. And that's where we do go to this third and final stage of a trial. And regrettably, that is the most stressful part of the process for everybody, because that is the time, we slightly touched upon it a moment ago, where we do find that there is cross-examination. And that's not a pleasant experience for anybody to have to go through, being challenged about your finances and being challenged about what you say your future should look like, essentially. It's not a pleasant process. But that is where, in the court-based system, unfortunately, there can be delays, and where we can go and use the private process, which is what we've just been talking about there in relation to going down the arbitration route to get this binding out-of-court decision in respect of somebody's finances. But you still have the benefit associated with the fact that you are hopefully doing things a lot quicker than if you were in the court system. You are having to pay for your arbitrator, but again, you're hopefully saving costs in the long term. And there is an element of privacy about an arbitration as well, because there is no risk of a judge publishing so there's no risk of an arbitrator publishing their judgment because they can't publish their award. A judge potentially could publish their decision because it's important for the profession and public policy. They won't necessarily name parties in their decision, but of course your finances potentially could still be discussed in a public judgment.
And the other thing about arbitration that I think is important to highlight is that you have so much control over what it is you're asking to be decided, in that if, say, there's 6 issues, you may have agreed 5 of them and there's one sticking point that you can't get over. So you can, perhaps with the assistance of a private FDR that you've already done, narrow the issues to that point and take that 1, 2, 3, however many issues it is. It may be the entire case and you can't agree anything and the arbitrator needs to look at everything, but you can have some control, which again helps to limit the costs and whatnot of taking it forward, but again strip some of the emotion out in terms of what you're being asked.
I think it is difficult, isn't it? Because once you get past the FDR stage, clients can often be very intransigent, and I think that's where it's important for clients to have a very good legal team giving them the best advice. Because whilst there's always a little bit of a grey area, you said earlier, Stuart, that different evaluators and judges might come up with slightly different outcomes, you know roughly where it's going to go. And I say to clients, usually at my first meeting is sometime during this process, you will hear from me or you'll hear from the counsel we instruct the advice that you need to hear, which is not necessarily the advice you want to hear. And there's always going to be bits where you have to say to the client, that's a bad argument, don't run that. But at the end of the day, you get some clients that will want to do it, to be told by somebody completely independent, sorry, you were wrong on that point. So yeah, we've talked a lot about the financial process. It is daunting, and I think the important thing to say is clients should take good legal advice because they need to know and understand what's going on. And we've tried today not to slip into too much jargon, and apologies to listeners if we have, but when you're seeing a solicitor, you should always say, hang on, what does FDR mean? What's a for me? So you understand what's going on. And what we have now, I think, is a private system running in parallel to the courts that is much more able to meet clients' needs. And although it comes at an extra cost over what would happen going through the court process in court, I think the benefits and the overall savings far outweigh the limited cost of you having to pay for a private evaluator to deal with. I mean, do you agree with those views?
Yeah, absolutely.
And I think that the toolkit that's now available in relation to the non-court-based dispute resolution options out there, it just means that your lawyer is able to act in your absolute best interests in terms of getting you out of a very difficult situation normally with the best outcome possible, having spent as little as possible on legal fees.
Yes.
And I think it's important to say that we've touched on a couple of areas of non-court dispute resolution today, but there are others. As you say, there's a whole toolkit. There's mediation, there's collaborative law, there's the one couple, one lawyer. There's lots of things that people can sort of draw on in terms of trying to get to an overall result that everybody is, can we say, happy with.
See podcast from...
Yes.
I think it's the courts are very much sort of self-help now. You should take much more responsibility for trying to sort out your problems. You shouldn't expect to go down a process and have a judge at the end of the day tell you what's going on. And you said, Stuart, that only 20% really get that far, and I'm sure that's going to get less.
Very much an option of last resort.
Thank you for the discussion.
Thank you.
Thank you very much for having me.